I'm Mangino. Welcome to the Mangino Talks podcast. We talk about everything that matters to Pittsburgh, from current events to Pittsburgh history, social issues to sports, politics to practical day-to-day life. But this episode required me to go to Pittsburgh sources to discuss a national story. The story that is absolutely dominating everybody's mind right now is the indictment of President Trump, former President Trump. 38 counts that Jack Smith ultimately brought through the Department of Justice. And it's interesting to note that it all appears as though the charges are all related to Trump's not taking the documents, but Trump's decision to not return the documents and then do all that he could to make it so that he could circumvent any efforts to return those documents. So to talk about the legal aspect of this, there's no one better to talk to than Bruce Antkowiak. Bruce Antkowiak from St Vincent College in Latrobe, former federal prosecutor, former defense attorney, now professor of law, and he joins us on Mangino Talks. Bruce, welcome. Great to have you on again.
As always, a wonderful pleasure.
Thank you very much for making time on this. First, 38-count indictment against the former president. Just the idea that a former president is being indicted and then what these counts detail, what are your thoughts about all of this at this point? The seriousness, the gravity, as Jack Smith mentioned on Friday?
This is not anything to kid about. And we are, of course, in completely uncharted territory with a former president now facing yet another bank of charges. These, I think, in many ways, far more serious and onerous than the first. These charges allege, and I took a brief overview of the actual indictment, these charges allege that the former president had in his possession national security documents that regarded weapons systems, battle plans, strategies for retaliatory strikes, maps of areas in which conflicts were occurring and being regularly assessed by military intelligence, that he had all of these things with him, and that repeatedly he denied having any such documents, made efforts through his lawyers to discount the possibility that any of this was still in his possession, and that he discussed these documents with individuals who had no security clearances and in circumstances in which he allegedly acknowledged that these were national security documents and that he should not be showing them to the people involved. Mm-hmm. So you're talking about a situation here of enormous gravity, and this is not something about, was a campaign was it really a campaign fund, or was it a private payment to the woman that he was allegedly trying to keep hushed about an affair? This is something far more serious, and it seems to me significantly well documented by the federal government.
Jack Smith spoke on Friday, all of about maybe 2 minutes and 30 seconds, no questions afterwards. What did you think of what he said while he took the podium?
I think that he knows that the counter to this is going to be, this is a political witch hunt. This is simply an effort to ensure that Donald Trump does not become the president of the United States again. And going on at length about that is not something any prosecutor will find any benefit in doing. A prosecutor is going to want to try to keep the focus of this on the fact that these actions were serious. They involved basic matters of national security, nothing that could even be questioned as being truly secret documents. And that besides everything else, and this is the one thing about all investigations, whether they be federal or state, the thing that the prosecutors dearly love is when the defendant tries to cover it up. Because proof of the cover-up is the most damning proof of all. It eliminates the possibility that you could say, well, yeah, wasn't I okay with having those documents? I don't understand what you're talking about. When you asked me for them, I gave them to you because I didn't do anything wrong. You can't say that if there has been proof of an effort to cover up the fact that you had them. And it becomes very difficult to have an innocent possessory of defense on something like this when you do. And the government is going to be simply relying on the gravity of the offense in both of those respects, the nature of the documents and the cover-up, to say, look, this is not a political witch hunt. This was a serious matter which we had to act upon in national security interests.
What is the significance to you that these charges are filed in the Southern District in Florida?
Well, they're where the documents were held. So it would make sense that there is certainly venue from a legal perspective. This is where the documents were held. This is where essentially representations were made that there were no documents of this nature being held at Mar-a-Lago. And to have brought these in Washington, D.C. would have been, I think, problematic from the government's point of view, because it would really have let the matter very dangerously become a circus if it was in Washington, D.C. Mm-hmm. Keeping it in the Southern District of Florida is proper legal venue and also a neutral enough site that I think the government is at least hoping that they will get a jury that will look at the matter objectively.
U.S. District Judge Aileen Cannon, Trump appointee, who happened to preside over the special master ruling that she gave back in 2022. She has been assigned this case. Your thoughts about that?
The former president appointed a lot of judges. The fact that a person was appointed by the president is not a disqualifying matter. Judges are essentially designated more by the senators from the state than they are the president personally. The president certainly would approve a judge, but they're going to defer to the senators. So this person is as neutral as anyone else, and certainly being an appointee of President Trump, there would be very little cause to immediately assert that she was biased.
There's a lot of discussion, too, about to what extent it was appropriate to charge a former president, one that is in the campaign to be president once again, that is there a weaponization of the Justice Department in this case? And my thought is that you either move forward with a case that you genuinely believe the evidence is there for, that you can prove beyond a reasonable doubt, and you do that regardless of who's going to be there, whether you're talking about the former president who wants to be president again or not. And then on the other side, do you purposefully not bring charges against him now, allow the political thing to play out, and then wait until potentially after he becomes president again to then bring these charges? And if they're that serious, if he's actually done what he's claimed to have been doing in these indictments, in a willingness to show classified documents to those that are not able to see these things, to store them in ways that you are not legally allowed to do so, does it pose a risk to put him back into the White House? Your thoughts about all those things?
Well, you want to hope that prosecutors really do act without political considerations. It's a rule of being a prosecutor on the state or federal level is your integrity depends upon the fact that you are putting political considerations aside. Now, the Justice Department has rightly been under a lot of criticism lately. There have been a series of hearings with former FBI agents testifying about their resignation from the job because they thought the FBI was being politicized. That is a cancer on the Justice Department. It's a cancer on the FBI, because in all of the days of the building up of the FBI through J. Edgar Hoover, the independence, the integrity of the FBI was lauded as its most significant trait. We are not only the best trained, best educated, best supplied federal agency, law enforcement agency anywhere. We are people of utmost integrity. Lose that, and it's very difficult to regain it. So, yeah, there's going to be clear indications that this was politically motivated. But if you decided not to bring this because the former president is a candidate, you're also making a decision for political reasons. And you rightly be criticized for that too. If you have the case, if you think the case is worthy of prosecution and you think the case has reached that point in the investigation, there is nothing more significant to obtain. Then you fish or cut bait. Mm-hmm. You either decide to put the case away and say it's not worthy of prosecution, or you go to a grand jury and ask them to indict. Right. And so I think that's the choice that you would hope the prosecutors in this case made. Put political considerations to one side, because after all, as we are seeing, indicting Donald Trump is not necessarily politically detrimental. True. It has become a motivating force for his support base. And whether that will continue is another matter. That's very interesting to me, whether that support base will remain undefiled as the allegations and the revelations of this come out. Because this, again, is much more serious than the original case brought against him by the New York District Attorney. But nonetheless, from a political point of view, the short term will be a strong benefit to him, without any doubt, on a political basis.
Walt Nauta, Donald Trump's aide, has been charged in this as well. He's looking at total time. He could be in prison for the rest of his life in federal prison. There's obviously going to be a lot of pressure put on him to turn on Trump, correct? The idea of offering some kind of a deal, listen, I'll talk, what do you want to know, and then turn on him. My thought is a couple of things. One, he's just an aide, so I doubt he has access personally to the kind of money it's going to take to defend yourself in a federal trial that involves the former president of the United States, who reportedly has billions of dollars. Can Trump fund this individual's defense? And what kind of legal risks are there in having your co-defendant fund your defense, if that could be a possibility?
Wow. I hate complimenting you because your head just grows bigger, but what a great question. Because this question does not just come up in cases of this incredible notoriety. This scenario arises a lot in circumstances the far more mundane.
Really?
Is where you have, oh my goodness.
Okay.
Where you have a group of drug conspirators who are alleged, low level, higher level, and you are the attorney for the lower level person. And you are told by the higher level person, I'm going to pay your fee. Now, can you accept that fee? Well, the bar has rules of this, and the absolute rule is that you cannot accept a fee to the extent that it would compromise your independent advice to your client. If you have assessed the case and the prosecutors have approached you and said, look, we will make a deal with you. You plead to 2 counts. Your exposure will be capped at 5 or 10 years. Mm-hmm. We will recommend to the judge a lenient sentence. And you understand that if your client goes to trial, given the weight of the evidence, he's likely to lose, and he is indeed likely to spend most of the rest of his life in a federal penitentiary. You have an obligation to advise your client what to do. And the fact of who's paying your fee is not to enter into it. It really becomes an ethical conundrum for the attorney. And, there have been times where, The client will say, no, look, there's no way in the world I'm going to testify against this guy. And that's all well and good, except when the evidence ultimately becomes known to you and you realize how much you are completely compromised by the evidence, and perhaps your only out is to make that deal. Your lawyer cannot put themselves in a conflict of interest situation by deciding not to advise you to plead, because then the tap from which the money is flowing is going to be shut permanently.
When it comes to these charges, the possible conviction, I'm hearing reports that this possibly could not go to trial until sometime in 2025. Does that kind of timeline make sense to you?
It is. There's going to be a lot of pretrial wrangling over this, a lot. There will be a lot of pretrial motions. And we have seen the length at which the idea of selecting a jury has occurred in a number of different cases, the Tree of Life case in Pittsburgh and others. Picking a jury for a defendant who happens to be the former president of the United States is not going to be the easiest task. To get 12 people plus alternates who say that they really have no opinion about the guilt or innocence right now. Mm-hmm. So judges tend to want to let a little time pass after the initial splash of publicity before they undertake such a thing. It's possible that this would not go to trial until then.
If he were to be elected president in November 24, and the timeline is potentially not to go to trial until 25, could that then delay the trial until he finishes his term as president? Or could he be serving as president and be tried for these indictments at the same time?
Again, another question that is as twisted as one could possibly be. The Justice Department has previously taken the position that a sitting president should not be charged, only because of the potential disruption of the administration of the government. Now, none of that would prevent an impeachment process, okay? The impeachment process could go straight ahead in this. And if, in fact, a sitting president he could be impeached right now. If he was the sitting president and he gets charged with this, he could be impeached for this. And certainly if he was sitting president and went to trial, he could get impeached certainly upon conviction. But the Justice Department has taken the position that would be a potential disruption, because he would then be the representative of the executive branch, and the executive branch would be prosecuting him. And that too would represent a conflict of some sort within the executive branch that would be difficult, if not impossible, to resolve. If he got elected in 2024 and the trial was not until coming up, prudence would dictate that you not try that case until after his term was served. Or if he got impeached, then you could go forward with the trial.
Yes. I also understand that if the trial could take place prior to the election and he were convicted, that alone would not keep him from being able to win the election that November. Is that true?
Yes. He being convicted does not prohibit you from seeking the endorsement of the voters of the country or the Electoral College. And, that could go forward. Now, again, that would present an incredible circumstance in the history of this country, that a sitting president would be looking at a sentence of some kind.
Wow.
The judge would have these counts certainly carry the possibility of imprisonment for President Trump, and imprisoning a former president would be the nightmare of all time for the department, the U.S. Bureau of Prisons, how would you incarcerate a former president? You
Right.
couldn't possibly
True.
put that person in a normal prison. Be an absolute nightmare.
I can easily see if Biden were to win re-election and there were a conviction that Biden would then pardon. Could you pardon in such a way to where you don't have to do the time, but you are also prohibited from seeking office again? Or does that only happen with an impeachment?
That only happens with an impeachment.
Okay.
And,
All right.
Biden would simply solve the issue of incarceration.
Gotcha.
With
I
that.
understand. One more
Yeah.
thing. The concern regarding the weaponization of the Department of Justice, regardless of who's in the White House, that a Republican administration would go after Democrats or a Democratic administration would go after Republicans. Is an answer to this issue the Supreme Court names and appoints the Attorney General? And what would it take to do that? And could you explain all that in less than the next 45 minutes to an hour?
First of all, it would take a constitutional amendment.
Okay.
Okay.
All right.
It would take a constitutional amendment because the Attorney General is an executive branch official. You would be giving the judicial branch of the government power to appoint an executive branch officer. That would amount to a violation of the separation of powers doctrine, and the Supreme Court itself would decline that power and jurisdiction.
Gotcha.
No matter how conservative they are and how much they would want to appoint somebody, they would never do it. Okay.
All right.
But then does that really solve the problem? I mean, Supreme Court justices are political appointees. There's no litmus test for how bright of a person you have to be, for how erudite you are as an opinion writer. You get appointed because of the political winds that are blowing at the time.
Mm-hmm.
And we have seen that happen. I mean, I could give you and bore the heck out of you a long exegesis about how the abortion case came about and how it came about essentially because of the changeover in the makeup of the Supreme Court, and how it could easily be reversed again if a few other justices retire and new people come in. So, it would not solve the politicalization problem to give it to the Supreme Court.
Bruce Antkowiak joining us from St. Vincent College in Latrobe on Mangino Talks. Bruce, thank you very much for your time. Do appreciate it.
It's always a pleasure. Thank you.
Thank you for listening to the Mangino Talks podcast. New episodes drop Monday through Friday at 3 p.m. Eastern. For more on me, the show, and anything you want me to talk about, be sure to visit manginotalks.com and send me an email. Follow me on your favorite social media platform by using @ManginoTalks, or you can just Google Mangino Talks. Once you find me, please like, follow, subscribe, and share the pages with your friends and your family. And thank you once again for listening to the Mangino Talks podcast.